Hello, my name is Ken Carlson. For the last 40 years, I've been a lawyer helping tenants. This video is to help California tenants who are worried about what to do with this COVID crisis. I'm a graduate of UC Berkeley and Loyola Law School. Since 1999, my office has been my website, caltenantlaw.com. Over the next 40 minutes, I'm going to help you get out of victim mode and learn what to do. You'll be surprised at how strong your position is and the things that you can do. I'm doing this as a free service for all the tenants in California. Right now, you're probably feeling like this guy, worried and harassed by your landlord who wants his rent. You don't have the money to pay because under COVID restrictions, you've been prevented from working. Even if you have the money to pay this month's rent, you very well may need that money to buy food and other things in the uncertain months ahead. Your employer may even have gone out of business or cannot promise to give you the hours you had before this fiasco began once the economy struggles to come back to normal. You may have been unable to work because you have to care for someone who's vulnerable to the COVID virus, or for a child who's out of school due to the closures. You're a victim of circumstance. It's so unfair. You feel the pressure closing in. If you have a business that rents commercial space, you have so much invested, and this is your livelihood, and yet you may have a long-term lease that your landlord threatens to hold you to, regardless of your inability to conduct business. If you rent your home, this is your home, but with the current restrictions, you can't even go out to look for another place. You fear being homeless or losing your business. The landlord refuses to understand or be flexible in this crisis. He's used to getting whatever he wants from tenants by threatening eviction to keep you obedient and in fear, even when he's wrong. When your only tool is a hammer, everything looks like a nail. Of course, the big question is, what's going to happen? First, let's talk about what's not going to happen. Maybe things that your landlord threatened, or that you heard could happen, or that you fear. We live in America. We have a Constitution and laws. The Constitution guarantees due process under law to everyone. It's an orderly process despite the chaos we're facing now. And you have the laws and legal process that must be followed, even by arrogant and bullying landlords. James Madison said, "The purpose of the law is to prevent the rich from always getting their way." After saying that, he was chosen by our founding fathers to write the Constitution, and later became our fourth president. Your landlord cannot simply throw you out or have you arrested for trespassing. He can't turn off your utilities or remove your furnishings or change the locks or ruin your credit. There are special laws that protect you from that, punishing the landlord harshly and awarding you a lot of money in a judgment against him. If your landlord tries that, you call the sheriff and press charges, as well as sue him. The sheriff will back you, not the landlord, and tell him he has to go through court in a case called an unlawful detainer. The landlord can't ruin your credit if you take the proper steps. If the landlord decides to file an unlawful detainer action against you, nothing shows up on your credit unless you lose the case. If you win, either by judgment or the landlord giving up and dismissing it, it never happened for credit reporting purposes. If the landlord turns his rent claim over to a collection agency, you simply write back to them that, key words, this is a disputed debt, and they must remove any derogatory information they've put on your credit and cease and desist any further effort unless and until there is a judgment. Now, before we feel too sorry for the poor landlord who's not getting your rent, let's consider the real situation. Every business has risks. A restaurant risks spoilage, weather, a fickle public, and health department degrading. Stores risk shoplifting, damaged goods, robbery, and accidents. Landlords have the fewest risks of all, because housing is a necessity of life which is in short supply. He's the top of the pecking order of creditors. His management is paid from rents, and there's no negotiation with his contracts. It's take it or leave it. Well, the only risk that the landlord really faces is not getting the rent. When the landlord finances the property through the bank, they have to convince the bank that they have the financial resources to pay the mortgage even if no rent is paid. Otherwise, the bank wouldn't lend. Obviously, a lot of these landlords simply lie to the bank to get the loan, sometimes representing that they will live in the home themselves in order to get the lower interest rate for owner occupancy. When they scream at you that they need your rent to pay their mortgage, you ask them if they defrauded the bank when they said that they didn't need the rent to pay that mortgage. You tell them that you'll contact their bank and check on that, which might result in an immediate foreclosure by that bank and bye-bye landlord. Now, under the COVID situation, loans backed by Fannie Mae or Freddie Mac offer a COVID forbearance amendment to the loan, which defers mortgage payments on the condition that the tenants are not evicted for non-payment under the recently enacted Federal CARES Act. As the COVID situation continues, other lenders may adopt a similar procedure as the only way out of the dilemma. The landlord can seek to refinance the loan, which will buy time and lower the payment. The landlord has other options that the tenants do not. The prudent landlord always tucks away part of the rental income into what's called a sinking fund, kind of a rainy day reserve if something should happen like fire, mold, pipe bursting, or disruption in rent. If the landlord did not keep a sinking fund, but instead greedily took all the profit he could squeeze out of the tenants to pay for gambling in Las Vegas, a new luxury car, and other frivolities, then he's just not a good businessman. It's like not having insurance and then seeking pity when something happens that insurance would have covered. The landlord who does not keep a sinking fund is foolish and reckless, not to be pitied. Don't feel sorry for the landlord. This is the risk he took. He just didn't expect it would occur. Neither did you. Under normal circumstances, if you lost your job, you'd still owe the rent. He went into the landlord business with eyes wide open, representing that he could pay the mortgage without rent. If he couldn't afford it and lied to the bank, then he's simply caught in his own trap, not an innocent victim of you or anyone else. Is your landlord smart, devious, or stupid? Where this is all going depends in large part on whether your landlord is smart, devious, or stupid. Your strategy in dealing with this crisis is directly related to who your opponent is and what they do. One size does not fit all. Learning what to do in advance, like you're doing here, gives you the smoothest possible path, the least stress and risk, and the greatest benefits. If you're a wimp afraid to exercise your rights or unable to handle conflict to stick up against the bullies, I can't help you. You may never have had to stick up for yourself before, but now your back is against the wall, and you should. A smart landlord takes care of his property and keeps the rent slightly below market to ensure longevity of his tenants. The smart landlord maintains a good relationship with his tenants, appreciative that they are paying his mortgage and providing him with a positive cash flow. The smart landlord will try to work with you during this crisis. Given the law, the court congestion, and the legitimacy of your position, the smart landlord will simply forgive the current rent and continue with your tenancy once you can afford to do so as the cheapest and best alternative. To the extent that you could then repay some of the past due amounts, he would also request that. But he would not bully you into a position where you have nothing to lose. The smart landlord will adjust your agreement to permit you to have roommates to share the rent without additional charge. His mortgage and whatever operational expenses incurred for a few months can still be written off as tax deductions and are already covered by his sinking fund. You probably don't have a smart landlord, or you wouldn't be listening to this, right? Still, it's helpful to understand what should have been done to compare with who you're actually stuck with. Now, before I continue, you might wonder if I'm just some radical landlord hater blind to the true position of landlords. Far from it. There is a right way and a wrong way to be a landlord. I am a landlord myself, which may surprise you. For half my career, I represented both landlords and tenants in these disputes. I know the landlord's side better than they do, but few landlords know or even consider the tenant side. Really, if landlords treated their tenants like any other businessman in America, especially the customers who pay them tens of thousands of dollars per year, I'd have to change my specialty. But I'm safe. It'll never happen. Something gets into the heads of these landlords, and especially the snide little people with power in management, and they become the ugly side of humanity. Really nasty, heartless, rude bullies. We need to change that. We need to teach them a lesson they will never forget. We need to take them down for the sake of our society. The devious landlords are really worse than the stupid ones, because they create and exploit your fear in order to manipulate you into a vulnerable position and defeat you. They have just enough intelligence to be sneaky. They use lies and intimidation to cheat you out of your rights. They are bullies like the stupid landlords, but bullies are cowards, and that's why they're bullies. They won't pick on someone their own size because they'd lose. They pick on someone whom they perceive as weaker, like you, their tenant. Their mistake. The devious landlords may call you into their office for an official conference about your rent delinquency, so that you're already obeying them and meeting them on their terms by coming to their office. They hand you official forms that they say you must fill out. These forms require you to disclose details about your financial situation, your social security number, your bank account, tax information, and other intrusions into your privacy as proof of your inability to pay by this information. The forms have you requesting that they permit you to postpone your rent payments. The forms require you to pay whatever you can now and commit yourself to a repayment schedule in an unreasonably short period of time. It's all done under the express or implied threat of eviction. Do it or move out. Well, don't do it. You have no obligation to go to their office. They can bring the papers to you. You're not going to the principal's office to be scolded and threatened. You're a customer, and they come to you. You probably have no obligation to give any information to the landlord or fill out his form. The devious landlord will say that you must do it, or that he has a legal right to have it. Really? Ask him. What law? A few of the ordinances I mentioned earlier do require that you give limited information, such as where or why you're not paying, but not what the landlord is demanding of you. Even the Commercial Code reasonable assurance doesn't apply to rent. They're lying about the law again. If they claim the lease requires it, really, what part of the lease? What section and wording are they talking about? There's probably no such requirement in the lease. Lies and manipulation are their hallmark, and you call them on it. You tell them you're going to warn all the other tenants about these tactics. You also have no legal obligation to make even a partial payment of rent now. If you've been economically harmed by COVID and the government response, as I'll explain in a minute. The contract says you owe the money, but the law says you don't, and the law prevails. The devious landlord is just trying to scare you into giving up money now for their own pockets that you will need later for food and other things during our national economic recovery. Even with the stimulus check you'll get, or the extra unemployment payment you get, which could help you pay the rent now, don't give it to the landlord. This is your rainy day money, and it will continue to rain. The devious landlord will try to force you to agree to a repayment schedule of the rent you're now unable to pay. You feel like you should, but it's a dangerous trap. And here's how it works. 1. The landlord knows you're scared of eviction and feeling vulnerable because you just don't have the money. Under the express or implied threat of eviction, he tries to manipulate you into signing an agreement to repay his rent by a specific day and dollar schedule. Sign or move out. Well, 2. Given the uncertainties of your immediate future, you don't know when you'll be able to work again, if you'll have a job, or if your income will be as high as it was before COVID hit. More realistically, many of you live hand to mouth, spending every penny of your paycheck, even before this COVID crisis began. For many of you, the landlord may already get more than half of your paycheck, with the balance going to food, medication, phone, gas, utilities, and insurance. Once you return to work, even if you then make what you did before, how could you possibly pay the back amount when there's nothing left? By not eating? How could you then promise to pay? From what? By making this promise on a schedule, hoping you can, you're making a foolish and unnecessary gamble. Number 3, and here's the trap. When you can't pay on that promised schedule, you lose your COVID excuse because you knew the circumstances of your possible inability to pay. Worse than that, the landlord claims that by making these promises you knew you couldn't pay, you committed false promise fraud to keep them from evicting you now. You're made out to be the bad guy because you signed with a gun to your head. You didn't have to make any agreement with them at all. In response to their pressure, you tell them when you know for sure what you can pay, you'll be able to negotiate a realistic payment schedule with them. Until then, you will not defraud them, because even amid threats of eviction if you don't sign the payment agreement, you are too honest to do so. And when will that be? You don't know. Nobody does. The devious landlord either realizes he can't win and reluctantly mimics the smart landlord, or joins the stupid landlord group by trying to evict you. Now, about the stupid landlords. The first sign that your landlord is stupid is that he's underestimated you. He doesn't talk to you to see what you know or how you want to handle this. He dictates. Most tenants don't seek legal advice, fall into the landlord's trap, and lose their home, income, and credit. You made the effort to find out your rights, the real circumstances, and the strategy that will not only make him lose, but really suffer for attempting to get away with it. You are a survivor. The second sign that your landlord is stupid is he's unaware of the law. He's so accustomed to bullying you to do whatever he says, he never considered it. Any idiot can be a landlord, and the arrogant ones are the stupidest of all. He thinks he is the law, because all this time, no tenant has ever questioned him. Drunk with power, he relies on scare tactics and a good deal of judicial corruption. What law? Let's start with this. Civil Code 1511. This obscure law, written in 1872, that's just after the Civil War, was last updated in 1964. It's hardly ever been used, but it will be at the core of this COVID crisis. It says that if you're unable to perform your duty under the contract, like paying rent, due to either government orders, like the stay-home and business closure laws, or an irresistible superhuman cause, like the COVID pandemic, then you are excused from performing. You're excused from paying rent under the lease. You are not in breach of contract. You cannot be evicted for non-payment of rent. You do not have to pay even a portion of the rent you would normally pay. There is no rent to pay by law, even if the landlord is jumping up and down screaming, "I want my money." He doesn't get it. Civil Code 1511 is your right not to pay. You can also download a copy of this statute from my website to read for yourself and show your landlord, who otherwise would accuse you of not knowing what you're talking about. Does that mean you never have to pay this rent? The law doesn't give us a clear answer to that, but practical circumstances will resolve that issue on their own. This COVID situation is unprecedented in its scope, severity, and universality across the nation. It has just never been thought out far enough to have rules as to how it will all be handled after the fiasco is over. There are only a few comments in case law that deal with that, although we will have some definite laws as the result of this. Let's say you're back to work and the landlord tells you to pay the current rent plus all the back rent, or you signed a repayment agreement that you can't meet. Well, you may still be unemployed or underemployed, or are already spending your entire paycheck on rent, food, and necessities with nothing left from which to pay the back amount. In that situation, you still have Civil Code 1511 to excuse your payment of that back rent, because your inability to pay back then, meaning now, continues, and that can go on indefinitely. Civil Code 1511 is not the only law that applies to help you in an eviction for non-payment of rent. In a breach of contract case, the judge can still award less than you are sued for, but in an eviction case, taking your home or business away, if the landlord demands even $1 more than you really owe, you win the case. Contrary to popular belief, a tenant fighting a non-payment of rent eviction has the greatest chance of winning because there are so many moving parts to go wrong for the landlord. For example, if you've ever paid late fees to this landlord, those late fees are illegal for residential tenants, and you are entitled to a credit against rent otherwise due. If you made a repair that the landlord failed to do, you're entitled to a credit against the rent for that. Substantial uninhabitable conditions in your home give you the legal right to withhold all rent until those repairs are made. If the landlord illegally constructed or converted buildings on the property, your lease is void and no rent is due. Overcharge of a security deposit, accounting errors, or even technical defects in the 3-day notice or the serving of it can win the case for you. The list is much longer, but you get the point. If you win the case on any of these, or Civil Code 1511, you win the case, and the tables are turned. I'll explain. The third sign that your landlord is stupid for trying to evict you concerns the condition of the courts. As I said earlier, the only way that the landlord can force you out is by the eviction process called unlawful detainer. In the normal course, the landlord has to serve you with a 3-day notice to pay rent or quit, and if you don't leave or pay the amount demanded by that 3rd day, that's 3 court days, then the landlord can file the unlawful detainer lawsuit. You fight back using the eviction process described on the game board of my site and request a jury trial. Without COVID, my record is 4.5 years of keeping a tenant in possession without paying. For your landlord, that was the good old days compared to now. What really makes trying to evict you a stupid thing to do are 6 things that result from COVID, the eviction laws, and the current court system. 1. The courts have essentially been shut down for a couple of months, creating an enormous backlog of cases that are all clamoring for attention. It would take years just to recover from that. Hearings that would have been a month away are 3 and 4 months away, and trials can be pushed out years away. Second, due to COVID, the courts also ordered that no eviction cases can be filed until 90 days after the governor declares an end of the state of emergency. That means that if the landlord gives you the 3-day notice today, he can't follow up with the next step to file the eviction lawsuit until months later. If the state of emergency ends, say, May 15th, the eviction case could not be filed until August 13th. And that could easily be September and beyond. Then, the governor issued an order in March that said that if you send the landlord a written notice that you're unable to pay the rent due to COVID, including loss of income or having to care for a child out of school or care for someone with COVID, and you give that notice no later than 7 days after the rent is due, your time to respond to the eviction case is extended to 65 days after you are served with the summons and complaint. Then, given the millions of tenants in California, almost all of whom have been paying nothing in rent due to COVID restrictions, there will be hundreds of thousands, if not millions, of eviction cases filed as soon as the courts do reopen and the 90-day period has passed. If the backlog just from the court closure were not enough, this tsunami of eviction cases will truly gridlock the courts. Judges can only hear a few cases per day, not hundreds. This means that every little motion you file that delays the case will have to be heard several months later. Jury trials will be put off indefinitely because there'll be no time to hear them, and jurors will be reluctant to miss any more work. You pay no rent all this time. Then, once the landlord gives the 3-day notice, he loses all control over the property. Things that would have been a violation of the lease are no longer in violation because there is no lease. For example, your lease prohibited subleasing. It doesn't anymore. That means you can take on roommates without leaving. Or, if you happen to find another place to move while the eviction is going on, you can move out and sublease your unit to someone else, providing an income to yourself without paying anything to the landlord. Maybe you couldn't have a dog before. Now you can. No lease, no rules. His only remedy is to evict you, and he's already trying that. The capper, of course, is that after having dragged out the eviction case all that time, you win. You win because of the COVID defense and or the other defenses that you raised. The landlord leaves the court empty-handed, but his downside is just beginning. Not only does he have to swallow all of his own legal fees, but he has no claim to rent because, well, he terminated the agreement. And your excuse under Civil Code 1511 still holds. He has to reimburse you for your legal fees, including any court fees you paid and attorney's fees you incurred. Now, you can take it up a level. Once the landlord starts evicting you, you don't have to merely fend him off. You can take the offense outside of the eviction case. While you may not have wanted to cause a dispute prior to the eviction, just to keep the peace, now it's a different story. He wants a battle, he gets one. To the extent that the landlord has defective conditions in the unit, which he has failed to repair, You can call in the city or county building and safety code enforcement people to cite the landlord. They may discover that there's illegal construction or defective conditions that must be corrected. The county health department, vector management, or environmental services divisions can also be called in to cite the landlord and require their corrections to be made as well. Vector management deals with things like mold, cockroaches, rodents, and bugs. And environmental services deals with other things like lead and asbestos. You can download the habitability checklist from my site to help you identify those defects and prepare a list to hand to the inspectors. Your landlord can't thumb his nose at them, or he goes to jail. So, he has to spend money fixing up your free unit or face jail. The citation also requires corrections within a deadline and a fine that he has to pay. The construction costs can be steep. Also, the fire department has inspectors who can cite the landlord over their concerns as well. Now, to the extent that the landlord may have defrauded the bank by saying he was going to live in the house rather than rent it out, you can contact his lender about that. If the landlord always required you to pay in cash, that might be to avoid telling the IRS about his secret income from you, and they would be interested in that tax fraud. If the resident manager has been nice to you, you might tell them about Order 5-2001, the Wages and Hours Regulations, that may reveal that the manager should have been paying no rent and getting paid for all the hours worked, which the labor board would prosecute against the landlord. After you win the eviction case, the real fun begins. Having terminated your tenancy with the 3-day notice and declaring a forfeiture, there is no lease. With no lease, there is no rent. Since the 3-day notice expired, even many months later. The landlord can't give you a new 3-day notice because no rent is due. You would have to agree to a new lease on your terms for any new rent to be due. And there are no damages, that is, the rental value of the place, for you staying there all this time for free, because you won the case. You were not unlawfully detaining, and therefore no damages. The landlord could file a case for declaratory relief to determine whether you owed anything, but that would be years away. If the landlord tries to evict you by a 60-day notice, you can defend it as retaliatory, revenge for your having won the eviction case. You remain in possession until he can find a legal way to evict you, or he pays you to go. Once you win the eviction case, you're entitled to have your legal fees paid by the landlord, as to filing fees you paid to the court and attorney fees you incurred. Better than that, you can sue both the landlord and his lawyer for malicious prosecution, and also sue the landlord for retaliation, breach of contract, and what other claims you have. It's a nightmarish backfire that the stupid landlord faces. If the landlord is able to succeed in evicting you by hook or crook, what do they have? After the COVID state of emergency is over, our economy is not going to just spring back. Many unemployed people will not have the money to spend in restaurants and stores or on services, so all businesses will be struggling to survive. The stupid landlord who thinks that once you're out he'll jack up the rent is dreaming. No one will have the money to pay for rent or will be staying in their units without paying, and the unit will stay empty, even if they're asking a lower rent than you were paying. Landlords have not seen a rental market like this in over 50 years. If only he had worked with you, he could keep his paying tenant and be grateful he did. But no, he was not careful what he wished for, and it came true. Now, if you do get a judgment against you, you still have the right to file a bankruptcy and wipe it out. In normal times, a bankruptcy can hurt your credit. However, under this COVID fiasco, tens of millions of people will be filing bankruptcy who previously had good credit. You'd be lost in the crowd, with banks and card companies having to overlook your COVID-related bankruptcy and keep you as a good customer. Also, if you do get a judgment against you, the normal blacklisting of tenants will be useless to prospective landlords because so many otherwise reliable tenants would be placed in that predicament. How does it all end? It really all depends, mostly, on whether you have a stupid or devious landlord. As I said earlier, the smart landlord forgives all rent until you can resume paying, and writes off the mortgage and operating expenses covered by his sinking fund as a tax deduction. For the stupid landlord, including the devious convert, he'll probably lose the entire property by foreclosure for failure to pay the mortgage. The bank may buy the property at its own foreclosure sale, or a third-party vulture may do that. Then there's a separate process to evict the tenant of a foreclosed landlord, which takes even more time, making it likely that they will just forgive all back rent and pay you to go. The new landlord will be buying the property at less than your landlord did, so they would be in a position to offer lower rents to keep you there. During the eviction process, realizing it could take too long to get to trial, or the futility of winning, the landlord could simply pay you to go, return your entire deposit, and forgive all back amounts. Bitter as it is to swallow, it is actually cheaper than facing what the courts will do. If your landlord proposes that kind of deal, even now, don't agree unless and until you actually have another place lined up with the signed lease and key in hand. I hope this has been helpful for you. I have a special COVID section on my website accessible from the Face page, which has the information and forms I've discussed to download and print out. Please remember to register to vote and vote. When politicians see high registration and high voter turnout in rental areas, they change their platforms to urge tenant rights to get that extra vote to put them over the top. 2/3 of California rents, but tenants are only about 5% of the voters. Let's change that and help restore fairness to tenants throughout the state. Finally, if you need a lawyer to help you with this, as you probably will, I have a list of all the tenant lawyers in California on my website. Look for the Tenant Lawyers button. You put in your zip code, and it lists the lawyers in order of distance from you, like a store locator, with all their contact information, website, and more. Please do not fall for the promises of the quack paralegals who promise the world, take your money, and fail to perform. The quack paralegals are all over at times like this. If they are a lawyer, they have a bar number and other information that you can confirm with the State Bar website. Thank you for watching. If you found this information helpful, please pass it along to others so they can benefit as well. I'm Ken Carlson.